Hi everyone, welcome back to Active Self-Protection Extra here with ASP CEO Stephanie. On today's John's Briefs, I want to put her on the spot, as I am wont to do, about the limitations of case law in terms of applying to your self-defense. Now more than ever, you need trusted coverage to help you win the fight after the fight. The company I trust and recommend is Firearms Legal Protection. They offer discounts on all their plans at the link in the description. I recommend the premium plan. So this is one that, gosh, I almost wish I could get my friend Mordecai to come in here. Summon him with the case law rant. And I think a lot of times people get this idea that, they understand, well, the case law says. And I think that gets people in a lot of trouble. We see that in the comments section all the time.
Right. And you see things like, well, talking about gun modifications. Well, we've never seen that really affect a legal matter. It's never come into play in the actual case. And that's just a total misunderstanding of the entire legal process and what the case law is and does. And yeah, it's a mess. Okay.
Now, of course, people are going to ask, I'm not an attorney. You're not an attorney.
No.
But so why do you think you have a qualified opinion in this?
We went over those in the last video, but to jump up again, I have taken about 130 hours of instructor level instruction in just legal, moral, ethical self-defense law. It's kind of a niche that I really enjoy and have spent a lot of time learning about. I would say compared to the average lawyer, that's well over 10 times the education they get.
It's over 100 times.
I'm trying to be generous. And not to say that, I know the law better than a lawyer does. I don't. I know this little area.
My friend Amanda, who is an attorney and has taken classes with us.
Right. She really does have a great understanding of self-defense law.
And okay, is an expert attorney. And yet she said when she looked through all her law school notes, which she still has, because she's my people and a giant nerd.
She's that kind of nerd.
Yeah,
I love it.
And she said she had one 45-minute lecture in crim law on self-defense law. So she had a grand total of 45 minutes of review of self-defense law in all of law school.
Right. So if you want to talk about process, proceedings, papers, how all that works, you need to talk to Amanda. But I do have a pretty good, and you have a pretty good understanding of this little piece, which is something a lot of lawyers don't.
So somebody says, yeah, but show me the case law.
Oh gosh, it's one of those things where you sit there and kind of blank out for a minute. How do I even begin this giant discussion? Because an awful lot of people don't really understand what case law is. So I'm reading about this case down in Arkansas or whatever. What does that have to do with me up in South Dakota? Nothing. And I think that's something that most people misunderstand, that they can't just Google and see, and well, I read in this article somewhere that there is no case law regarding this. It's just a radical misunderstanding of how it even comes into play.
So to me, a big thing you got to understand here is the jurisdiction that you're talking about. Because I think a lot of people confuse, they think, oh, wait a minute, I live in the Ninth Circuit, and so that's where I live, in Arizona in the Ninth Circuit. And so what happens in the Ninth Circuit always applies to me. Well, wait a minute, I'm here in Arizona. That might be true federally, but it's not true of state law. You can have a case out of Idaho, which is also in the Ninth Circuit, but it's state level law, not federal law. And so what happens in the Ninth Circuit is completely irrelevant to the state level law. And so you go, well, wait a minute, we have, or in Idaho, we have a case in Idaho case law that's this. That's great, and for state level law, that might really do something, but for federal laws, it has nothing to do with federal laws. So you have these two completely disparate jurisdictions, federal and state criminal law.
And even within your state, you may be in a different region. So this case may come out of a different region than you were in. In my state, we're all one big region, but if you're at different levels, so just because it happened in South Dakota might not mean it affects me.
And I think the other part people really misunderstand about case law is when you say, wait a minute, why don't we see case law on things? Well, you don't get case law out of cases, quite frankly.
Yeah.
Is that if a case gets decided on its merits and then it dies there, in other words, the decision is accepted, you'll never see anything on that. The only time you see case law is when a jury reaches a verdict or a finder of fact, a judge or a jury reaches a verdict. then that is appealed. So, and they don't appeal it based on, "Nuh-uh, we disagree."
Right.
They appeal it based on some application of the law incorrectly to the facts. So
They're not retrying that case that, we're appealing because we're actually innocent. It's an actual legal matter.
Right. It's did the law get applied adequately to the known facts?
Right.
So the facts have been established. They've gone through all of the discovery, all of the pretrial, all of the presentation of the facts. We all stipulate to all those.
Right.
So now then, did the law get applied correctly to the facts? And then that higher court, whether it's an appellate court in the state level, when you start to get to circuit courts in federal jurisdiction, those kinds of things, then they will argue these facts apply to this law in this way and usually give a principle for it.
Right.
But the only time that might apply across all the land is if it's a Supreme Court appellate decision. The Supreme Court is the highest appeals court in the land. And even then, we can see things like, right now, I think we're having real problems because DC versus Heller and McDonald versus City of Chicago. And there's all this discussion about, wait a minute, is it getting applied in the circuits in the way that the justices told them to do that? You're going to see, my guess is, some more cases coming forward on that.
Yep.
And so people come and they say, "Oh, John, what does the case law say?" And I go, "You probably don't understand case law." I think the other side of this is that there could be case law that applies to your case that has nothing to do with firearms.
Right, exactly. It may have something to do with automotive parts in a, non-custom or custom automotive parts, and that might actually apply to what you're talking about,
Right.
and have nothing to do with self-defense.
And the crazy part is that you probably don't have access to case law files.
No.
There's a few that'll show up online. Some of the bigger ones will get posted online. But generally speaking, the people that compile that stuff, they want big money for that. And the only people that are going to do that are attorneys because it's a professional need. So when somebody appeals to the case law, what's your reaction?
My first reaction is, again, they just don't understand, and how much can I explain to them in the short time that we have to help them understand? Because even if you could find relevant case law that was controlling in your area, and you had access to the tools to find that, then you have to find out, well, was it applicable at the time of what I did? Is it even applicable, or did it happen before this time? It's so confusing, and that's, the more I learn about this, the more I understand it's almost impossible to really go into something and say, this is the way it is. This is the case law that's helpful. This is what the law says. I'm finding that's very rare to actually be the case.
And I think in use of force cases, a lot of times people there's two big cases they point to, well, three in some cases. So Terry v. Ohio, which was about, can they, cops stop and frisk a guy? And that's where the basis of the Terry stop came from. Number two, Graham versus Connor. Number three is Tennessee versus Garner. And so you go, oh, okay, wait a minute. So those are controlling federal cases. Yeah, in federal courts dealing with law enforcement use of forces, those ones have been decided across all of the Supreme Court and applied through the circuits that, yes, everybody's going to do that. Doesn't have anything to do with what happens in a case in, say, Georgia, and what state law says about how those officers acted, because guess what? Tennessee versus Garner is a federal law, is a federal case, and federal case law that has nothing to do with state level laws. So if they're getting charged or not under state laws, that federal precedent has nothing to do with it. Oof. So if you want to know more about that, go to law school. There's where the reality is.
If you want to be able to find all of that stuff, you're probably going to have to pay a bunch of people to search a bunch of databases that are expensive to learn everything you need to know in your state that day.
So again, at the end of the day, what I want you to recognize is that we do have a labyrinthine court system in America, and multiple jurisdictions in play. City courts, state courts, county courts, federal courts, and all of those play by their own rules. And what is controlling in terms of case law on one is not necessarily on another. And when we say, wait a minute, there is controlling case law in this particular issue, I'll give you an instance. In Michigan law, they have a case law that the mere pointing of a firearm is ordinary physical force, not deadly physical force. And that is a known case in Michigan that applies to Michigan law and the way that they do things in Michigan. Okay, fine. Has nothing to do with, say, somebody does something here in Arizona.
Right.
Or whether or not the feds can give you a hard time.
Right.
So from a perspective of everyday application of force, honestly, I would ignore case law completely. I wouldn't appeal to that as the place where you would get your understanding, because you better make sure that you understand it well.
Yeah, it's not a place I would ever go as someone that knows quite a bit. I know that I can never learn enough in my limited time and resources to have a really good understanding. That, because it's going to even change from day to day. Next month, it might be totally different. There may have been a case tried between here and there that changes everything.
Yep.
And you may not know that. So unless you are on top of it, that is your job. You're a lawyer. And even then, they have to pay people to search and find and compile.
One last bit on that, you might read some, and I'm a junkie on this stuff, guys. Like, I have a copy on my hard drive of DC versus Heller and McDonald versus Chicago. Why? Because I'm that kind of nerd. And I'll tell you, until you've gotten a pretty good understanding of legal definitions and how lawyers use words, the Supreme Court did not write those decisions for average Americans. No. They wrote them for attorneys. They wrote them for judges who are attorneys and lawyers to be able to read in their little nifty individual language.
Right.
So watch that stuff. And again, I want you to just be cautious, because I think people go into these things and they think, I know what the heck I'm talking about here, when the reality is they probably don't. Steph, appreciate you.